Hello, once again. My name is Frederik Harhoff. I'm the Professor Emeritus of International Law at the University of Southern Denmark. In this session, we will deal with the actors of the international legal order. We touched upon this issue in the last session, but I will go into depth this time here. As we say, the actors in the legal system are basically the subjects of international law. Who are involved, who are obliged by the legal system. Any legal system needs to have subjects because the subjects are the institution, the entities to which the rules are addressed. So in the international legal system, as we said last time, the primary subject is the state. And then we have organizations of international states. They're just simply called international organizations. And then we have customary law. The first subject we have is the state. States are the primary subject of the international legal system. Also, along with states, we have organizations of states, because states may join each other and form an international institution, an international organization. And that organization, too, may also become a subject of international law. And then the third group we have in the group of subjects of international law is the individual. So these are the three primary subjects of international law that we have. Let me take them one by one. A state. Sovereign states are subjects of international law, and to become a state, we need to look at some requirements. These requirements are written down in the Montevideo Convention from 1933. The Montevideo Convention sets out what it takes to become a state, or rather the four requirements that are needed for any state to appear as a legal subject of the international legal system. First of all, a state must have a fixed territory. That means to say that the state cannot exist without a territory. We had maybe an example of an international legal subject that did not have a territory, namely the Vatican Church, because the Vatican Church has subjects. It's a subject, but the norms of the Vatican state is all the Catholic priests in the world. But they live all over the place. So as such, the Vatican is perhaps a state. Maybe they have a small territory around St. Peter's Church and the cathedral in Rome. But other than that, the subjects of the Vatican legal system are spread all over the world. So, but that's a rare example and discussed mainly for academic purposes. But it's good to know that you can actually think of an international legal subject that does not have a fixed territory, namely the Vatican State. But other than that, every state must have a fixed territory. What do we mean by fixed territory? We mean that there has to be borderlines between adjacent states. And so if two states are adjacent, there shall have to be a borderline between them to separate one territory from the territory of the neighbor state. Either that or towards the sea. If it is a coastal state, then the territory of that state will stretch from the beach and then 12 nautical miles out into the sea. That is the territorial sea that belongs to the state, and that is also fully part of the coastal state's territory. Then we also have the airspace over the territory, and how far up does the airspace go? That is a point of discussion. We normally say that the airspace goes as high up as normal flights can fly, passenger flights and maybe military jet air flight. I don't know how far up we are able to fly on a normal basis, but most people tend to believe it is somewhere between 25 and 30 kilometers. That's as high up as the airspace goes. Now, that was the first condition. So the state must have a fixed territory. We have a few examples of borderlines that either do not exist. For instance, in the desert, somewhere in Africa, some of the countries that are coming up to the Sahara Desert, I mean, in the middle of the desert, it's impossible to have a fixed border and a wall, for instance, and people patrolling the borderline all the time. That is simply not practical. So there are places in the world where there is no fixed territory. But again, these are exceptions. So the normal main rule is that a state has to have a fixed territory with borderlines, either toward adjacent state or towards the sea, the high seas. Then the second condition is that the state must have a permanent population. This means that if you have a state where there is no permanent population, but only if you have a territory where there is no permanent population, but just a territory where nomads or people are crossing back and forth all the time, that is not sufficient to establish a permanent population. People have to live there. They don't have necessarily to be citizens of that state, but at least they have to live there permanently. I think all countries in the world today have their own citizens, but they also have a number of foreigners who have taken up residence permanently on the territory of that state. And they form part of what is required by the Montevideo Convention, namely a permanent population. Thirdly, a state must have a set of institutions that are able to effectively control the territory of the state. That is to say, basically, they must have a legislature, that is to say, institutions that are able to pass laws that are binding upon all the people who live permanently on the territory and also those who are there just for short periods. They must have executive authorities that are able to execute and uphold the law in the territory of the state. And they must have a judiciary, that is to say, a set of courts that are able to establish whether or not the laws that have been adopted by the legislature have been violated or not. And this is an interesting thing that I would like you to pay attention to. The legal system is the only system in the world, if you compare it to political systems or religious systems or other systems, that have an institution that has the power to determine finally and authoritatively how the laws should be applied and interpreted. So we have in the legal system an institution that can have the last word. This is how it is, full stop. If you look at the political system, such an institution does not exist. That has to do with the fact that the international legal system is indeed a very special legal system, at least if you compare it with domestic law. So finally, the state must have the power or the ability to enter into negotiations with other states and conclude agreements with them. So that is to say, the treaty-making power must also be one of the assets that any state must have. Then, as I said, states can come together and bind themselves up in an international organization that they will be governmental international organizations, you see. So when we say international organizations, we normally think of organizations that have been joined by states. You also do have international organizations that are non-state, private companies and organizations such as, for instance, the International Committee of the Red Cross. They are not made up by states. Or you may have Amnesty International or Human Rights Watch. These are also international organizations, but they are non-state international organizations. Finally, as I said, we have individuals. They may also, in some respects, be subjects of international law. The primary place where we're looking is to the law of armed conflicts, in which individuals are carriers of both international legal duties and international legal rights. They are obliged to abide by the Geneva Conventions, which are the basic conventions underlying the law of armed conflicts. We will get back to that later on. And also, if we look at individuals in terms of human rights, of course, as the word tells, provides rights to individuals under international law. Thank you so much for attending this lecture. Next time we will look at jurisdiction. Thank you so much. Goodbye.